여러분 안녕하십니까? 한지훈 판사입니다.
Hello, this is Judge Han.
편안한 휴식
Hope you
취하셨길
had a
바랍니다.
great evening
오늘
yesterday.
오전에도 아주 유익한 세션이
And
준비되어
we
있습니다.
have
10시 정각에
sessions ready for you
시작하겠습니다.
today as well. So we will begin the fourth
지금부터
session
2024년
at 10
국제
a.m.
컨퍼런스
So we will
특허
kick
법원
off
컨퍼런스
the
4세션을
2024 International
시작하겠습니다.
IP
이번
Court
세션에서는
Conference.
소송 절차의
Session 4.
효율적
In
운영을
this
위한
session, we'll
각국의
be
실무에
covering
대해서
the topic of
살펴봅니다.
best practices for efficient litigation
본
process.
세션을 이끌어
And this will be led
주시겠습니다.
by
큰 박수
Young-gi Kim,
부탁드립니다.
IP High Court Judge of Korea.
Okay, good morning everyone. How's everything going today? Hopefully all of you are enjoying this conference as much as possible, especially the gorgeous view from this venue, right? Yes, I am Judge Young Kim from IP High Court of Korea, which is the very first IP specialized court in Asia. And welcome to this very interactive session with very well-renowned judges about IP litigation system. An efficient litigation process is one of the key challenges for courts around the world these days. And to achieve the goal, each jurisdiction has adopted various systems and legal instruments. Can you help the slide? Oh no, not yet. Okay, this one. The title of this session is Best Practices for Efficient Litigation Process, which will specifically focus on patent infringement litigation and revocation appeal procedure. And we'll take a journey from filing a complaint to a judgment and appeal. For fruitful discussion, we already exchanged long questionnaire, and as a moderator, I picked up a very interesting and crucial topics for discussion. I'm sure that this session will provide us the best opportunity to understand and learn from each other and to find which one is the better. Okay. Now, let me introduce our renowned special speakers for our session. For this session, like the last year, an amazing 4 judges have joined us. I will introduce them under the doctrine of ladies first. Okay, we have Honorable Judge Kiyo MATSUMOTO from the Eastern District of New York, United States. Good morning, Judge. Yeah, how do you feel this morning?
Well, thank you. Good morning.
May I have a very quick question? I like the photo, so when was it taken?
You can tell I look much younger. That was an original court photo that was taken of me when I first became a judge. So it's quite old, and I am quite old too.
Oh, really? I thought it was just yesterday. Yeah, honestly, Your Honor. Okay, next to her, we have Honorable Judge Jörn Feddersen from Federal Court of Justice, Germany. Hey, Judge, are you enjoying this conference?
I'm enjoying myself very much. Thank you very much.
How was it last night's performance, Korean music performance? Did you like it?
It was so beautiful. I was really blown away. It was so lovely.
I'm so happy to hear that. Okay, we also have from Tokyo District Court, Honorable Presiding Judge Masaki SUGIURA. Good morning, Judge. I heard that this is your 3rd visit, right, to Korea. Which one is the best?
This time is best. Of course.
Perfect answer. Thank you. And last but not least, we have Honorable Judge Jaepil from IP High Court of Korea. Thank you so much for joining this session, Judge Yoon. Okay, Before jumping into our session, just housekeeping comment, I have this one. Actually, this session is prepared for very comfortable discussion among the judges, so it's a little bit different from other sessions. Please understand that. Okay. Let's start with very general question. The question goes like this. Judges, are you ready? Okay. Please introduce one of the most significant measures of your country adopted to handle patent infringement litigation or revocation appeals efficiently. Who will go first? Any volunteer? Oh, Judge Matsumoto.
Well, in the United States, the district courts are courts of general jurisdiction. So unlike many courts, including those of my colleague Judge Cheney, who you heard from yesterday, we are not specialists in the fields of engineering, science, and technology. Rather, for example, I was a journalism major in college. So we handle all matter of civil and criminal cases. And one of the significant tools that we use for case management are the Federal Rules of Civil Procedure, our local patent rules, and also the claim construction procedures set forth in the Markman case. This is a hearing during which parties present evidence and ask the court to construe the meaning of the claims. That construction helps define the course of the litigation and the parties' conduct of the litigation. Thank you.
Okay, thank you, Judge. And let's visit Germany. How about in Germany, Judge?
Thank you very much. Now, as you, of course, know, Germany patent law follows the system of bifurcation, which means that revocation and nullity proceedings and infringement proceedings are to be pursued in different court venues. Infringement suits start at the district court, Landgericht, and in order to facilitate specialization, the Patent Act allows to award exclusive jurisdiction to specific district courts over patent suits in one or several states. So the most important patent infringement venues, as you know, are the district court in Düsseldorf, Mannheim, Munich, and Hamburg. This enumeration sounds familiar after yesterday when we heard about the UPC. So maybe it's no accident that the 4 German local chambers are located in these cities. The district courts decide as specialized panels of 3 legally qualified judges, and those decisions are subject to appeal to the higher district court, which again decides by a panel, specialized panel of 3 legally qualified judges. Legal review of decisions on appeal lies with the Federal Court of Justice, with my court in Karlsruhe, in fact the 10th Civil Senate, and the panel sits as a specialized panel of 5 legally qualified judges. If the higher district court grants leave to seek review, I must add, or the Federal Court of Justice sets aside the higher court's denial of leave to seek review. Now, as I said in the beginning, exclusive jurisdiction over revocation appeals and nullity proceedings lies with the Federal Patent Court in Munich, Bundespatentgericht, which means bifurcation, that invalidity of the patent cannot be invoked as a defense or counterclaim in infringement proceedings. However, infringement proceedings can be stayed while revocation or nullity proceedings are pending. The Federal Patent Court decides upon revocation appeals as a panel of 2 or 3 technically qualified judges and 1 legally qualified judge. A panel of 3 technically qualified judges and 2 legally qualified judges handles nullity proceedings. Also, revocation decisions of the Federal Patent Court are subject to appeal, again to the 10th Civil Senate of my court, the Federal Court of Justice, under the prerequisite that the Federal Patent Court grants leave to appeal, or again, the Federal Court of Justice sets aside the denial of leave to appeal by the Federal Patent Court. And nullity decisions of the Federal Patent Court are subject to legal review by my court, always. Thank you.
Okay, Judge, when you say court in Hamburg, is in Hamburg, not in Hamburg, right? Hamburg. Okay, thank you. And I heard that the remote conference trial is popular in Germany, right? Remote conference trial, the judges stay in different places and have...
In fact, yes, our Code of Civil Procedure provides for the possibility of a trial by video conference. In fact, we had this provision included in our Code of Civil Procedure for more than 20 years, but I think you could call it at those times the sleeping beauty of Civil Procedure Code, because it was very rarely used. And then what happened, COVID came and kissed the sleeping beauty awake. So that's a weird metaphor right there. And then we had, during COVID, we had thousands of video conferences. I'm very interested to hear about my colleagues, but I'm quite confident that we are all in the same place as to this feature. It was the understanding, it was basically no question that the court had to be present at the location of the court, and then the parties and witnesses and so on could be included by video conference. We learned during COVID, I think maybe this is also a shared experience, that the more flexibility you have as to procedural rules, the better we can cope with crisis situations. So after COVID, finally was gone, discussions emerged how to facilitate video conferencing even further. And so the discussion concentrated on the question whether even the court should be allowed to be at a different place than the location of the court.
Okay, Judge, thank you. Very quickly then, do judges prefer the video conferencing trial or to just traditional one? Just quickly.
I think we heard that yesterday from Judge Kelden, and I very much concur with that view. I think this is also a shared experience. Okay, I'm sorry, I'm talking too much. Now, I would always prefer a personal oral hearing over a video conference. You want to see your opponent freeze in shock by upon a word of the judge, right? You want to see the facial expression of the judge while you make your argument. You want to factor in all this information in your trial strategy, and we all know that communication is not only about distant visuals and sounds, but there's non-verbal communication that is very important, and I also want to see the face of my judge colleagues, my fellow judges, when they say something. So really, I think I would always prefer a personal hearing over a video conference.
Okay, thank you, Judge. I think that Judge SUGIURA is expecting his turn, but let's be Korea first. How about Judge Yoon?
It's an honor to discuss these important topics with distinguished expertise. While preparing for this session, I realized the countries around the world are putting in a lot of effort to improve the efficiency of the litigation process. Now I'd like to introduce an important change happening in Korea. One key measure introduced is, of course, jurisdiction centralization. And at the center of this system is the Intellectual Property High Court of Korea. The IP High Court of Korea was established in 1982 and exclusively appeals against decisions made by the Intellectual Property Trial Appeal Board, IP10. At that time, infringement lawsuits concerning registered IP rights such as patents, utility models, trademarks, and design were treated like general civil cases in terms of jurisdiction. However, with enforcement of the amendments to the Civil Procedure Act and the Court Organization Act in 2016, jurisdiction over infringement lawsuits became more centralized. Since then, first instance jurisdiction has been assigned to 6 district courts located in regions with high courts, and appellate jurisdiction has been centralized in the IP High Court. This concentration has been praised by both academics and practitioners for enhancing the expertise and efficiency in handling cases. Currently, discussions are underway within the Presidential Council on Intellectual Property to extend this centralized jurisdiction to other types of cases that require specialized understanding and analysis of intellectual property. These mainly include trade secret and preliminary injunction and criminal cases related to patent infringements. At the IP High Court, High Court Judge Young-gi Kim and Gisu Kim are also participating in this council. I'd like to this opportunity to thank both of them. Thank you.
Thank you, Judge Jörn. You're sharing the concentration of jurisdiction in Korea. Thank you. And Judge SUGIURA, it's your turn.
Sorry. I think the most significant measure is the exclusive jurisdiction on patent infringement litigation and revocation appeals. The Code of Civil Procedure provides the exclusive jurisdiction of Tokyo and Osaka District Court for the patent infringement litigations, and the Tokyo District Court has 4 specialized divisions for IP cases, and Osaka has the 2 divisions for them. And IP High Court of Japan has the exclusive jurisdiction for appeals against the judgment by the aforementioned district courts. And the Patent Act provides the exclusive jurisdiction of IP High Court as a special branch of Tokyo High Court for the litigations against the decision on a trial or appeal, etc., by Japan Patent Office. These provisions on the exclusive jurisdiction for patent litigation aim to increase the effectiveness and efficiency of court proceedings and enhance the specialized judicial system for IP-related cases by the extended experience of judges and other relevant court officials. I think especially from the viewpoint of capacity building, it is important that this gives young judges will form a close relationship among relevant players related to IP judiciary. Thank you.
Thank you, Judge. I heard that you also have technical advisors in your course. So very quick follow-up question. Are they a full-time worker for your court, or they are just appointed for specific case temporarily?
Thank you for your question. Technical advisors are part-time national officers appointed by the Supreme Court, consisting of leading experts such as university professors and researchers of public institutions. They provide explanation on the highly specialized and technical matters in dispute based on their expertise. On the other hand, judicial research officials are full-time court staff members, consisting of former JPO trial examiners and patent attorneys. Thank you.
Okay, here I think we find very similar practice among Korea and Japan because we are neighboring countries. Also, IP High Court and Seoul Central District Court also have full-time technical advisors in court. Okay, Justin, right? Yes, okay. It was a very general question. Now it's time to get into the main point from the filing complaint. Let's circle back to United States. This question goes to Judge MATSUMOTO. Does your court provide guidelines to parties on the necessary information for complaints? What measures does your court take for making them to? And what is the sanctions for failure of compliance?
There are no specific guidelines as to what a complaint must include, but the United States Supreme Court in two related cases, you've probably heard of Bell Atlantic versus Twombly and Ashcroft versus Iqbal. These were decided in 2007 and 2009, required that a complaint must allege sufficient facts to state a plausible claim for relief. Federal district courts have applied different pleading standards alleging direct infringement and indirect infringement, and they may require additional facts. At a minimum, the facts alleged have to state a plausible claim. However, if a complaint fails to state a claim, or if a defendant believes it does, then it may move under the Federal Rules of Civil Procedure 12b-6, which is dismissal for failure to state a claim. There, the court will construe the complaint in the light most favorable to the plaintiff and assume that all the facts alleged are true. Then the court has to evaluate whether those facts, taken as true, will state a viable claim. If it does not, the court may dismiss the complaint, generally with leave to replead, meaning that the plaintiff gets another bite at the apple. In order to improve efficiency, what I and my colleagues often do is if a defendant wishes to make a motion to dismiss for failure to state a claim, we will have a conference and I will ask the plaintiff whether there are additional facts that they can allege that will satisfy the defendant's view that the statement of facts is not sufficient to state a claim. And oftentimes they will take that opportunity, and I will save the trouble and expense for the parties of making a motion.
Thank you, Your Honor. Then those kind of things are specified in your local patent rules, right?
Not just the local patent rules, but also the Federal Rules of Civil Procedure, which apply also to patent cases.
Okay, thank you. Then how about in Korea, Judge Jörn?
Thank you. Except for the general provisions set by the Civil Procedure Act, there are no specific guidelines related to patent infringement. However, there are guidelines in place after submission of the appeal brief. Upon receiving the guidelines are available on official website of the IP High Court. These guidelines are also available in an English version. Upon receiving an appeal brief, the court issues an order to prepare for elucidation, requesting the parties to refer to the guidelines on our website, including the link when submitting claims or evidence. It also notifies that non-compliance may result in disadvantages such as the court refusing to accept claims or evidence submissions under Article 149 of the Civil Procedure Act. The guidelines set out the basics for argument and hearing procedures, aiming to enable swift, efficient, and specialized trials. Given the court's specialization, most representatives are well versed in its practice, leading to general adherence to the guideline. However, as the guidelines just guidelines, parties cannot be penalized solely for non-compliance.
Okay, when you say guideline, it means that the practice directions for civil appellate trial and revocation trial, the formal name, right, of this IP High Court. Okay, thank you, Judge. Okay, let's forward. Okay, this phase is early stage case management. This question goes to Judge SUGIURA first. Question is like this. Does your court establish a plan for case management at an early stage? If so, what does this process entail, and what measures can the court take if a party does not follow the established plan?
Thank you. In many cases, the court established a plan for case management in the initial phase. The plan will be established based on the discussion between parties and the court. In the plan, the court will set the frequency and deadline for submission of preparatory documents and evidence from each of parties and may set the date for explanatory session about the allegation if necessary. Therefore, on the process to establish the plan, the court will look forward to lead the discussion actively, but not play the decisive role. If the party has presented after the deadline to submit allegations or evidence intentionally or through gross negligence, and the court finds the conclusion of litigation will be delayed because of it, the court may rule to dismiss such allegations or evidence without prejudice upon petition or sua sponte.
Okay, thank you, Judge. Before I move to another judge, I want to just add one more comment about the current practice, about the guidelines. As Judge Jörn mentioned, there is no harsh sanctions against those guidelines, but it might affect the result of the case, right? Because the judges don't like they're not complying the guideline, right? Okay, thank you. And then how about just visiting Germany, Judge Feddersen?
Thank you. Now, first of all, there are no special requirements for filing patent infringement actions, and also the courts usually do not provide guidelines in advance. However, and we heard about that yesterday, and I very much sympathize with the statement that that Judge Cheney made here, who said that the enforcement of deadlines is key to expedient trials. And this is very much the spirit, I think, that also is reflected in the German procedural law, because each party has, the option to, now first of all, obviously the plaintiff has to state his claim, then the defendant can reply, then the plaintiff can again answer to that, and then the defendant has another chance to reply, and then the case will be resolved in one hearing. And in the meantime, if the court finds that information is lacking, it will advise the respective party and tell the party, this is not sufficient, either the claim or the defense. Of course, having in mind the fundamental rights to a fair trial and efficient judicial remedy, fundamental rights, not only in Germany, I suppose. So this duty to notify the parties is very important. And also, after all this business has been concluded, if the deadline is over, you run the risk that your facts that you present too late after missing the deadline will not be considered, and you don't want that. So you rather comply with the deadlines.
Okay, thank you, Judge. Judge Matsumoto, United States is very famous for its case management conference. Could you share your practice about that?
After a case is filed and the defendants are served with a summons and complaint, a court will issue an order scheduling an initial conference. And at that conference, in a patent case, the court will set deadlines and dates for certain proceedings. For example, claim construction filings and hearings, proposed expert discovery, a proposed format and deadlines for service of infringement, invalidity, and or unenforceability contentions, dates for disclosure of claims and infringement contentions identifying prior art that allegedly renders obvious each of the asserted claims, and any other grounds for invalidity or unenforceability. The parties must update and supplement their responses, which could cause some consternation when there are updates, but it is an obligation. What you don't want is unfair surprise. So if a defendant is going to rely on advice of counsel, they must disclose the opinions of the counsel on which the alleged infringer relied, and provide ultimately, after conferring with the parties must provide a joint disputed claim terms chart with proposed constructions for the court to consider. The court will then consider any motions or trials or hearings.
Okay, thank you, Judge. Let's move to next step, next phase, the pre-trial evidence collection. Let's start with Judge SUGIURA. Yes, the question goes like this. There are two evidence collection systems primarily used worldwide. One is the discovery system used in common law, like United States, and the other is the judicially led evidence collection system. Question, would you share your court's evidence collection measures in detail, which has been specially adopted for effective evidence collection? And another thing is, what measures can your court take if a party fails to comply with?
Thank you. In Japan, parties should submit allegations and evidence according to the burden of proof, and the court should make its decision based on them submitted by parties. Therefore, the parties bear responsibility to collect evidence primarily. In order to collect evidence, parties can file the petition for preservation of evidence and dispositions on the collection of evidence against the court before the filing of the complaint. After filing the patent infringement litigation, in order to collect evidence, parties can file petition for an order to submit documents provided the Civil Procedure Code and Patent Code. And motion for issuing an investigation order to an investigator provided the Patent Act. In case that the adverse party of preservation of evidence, the order to submit document and the investigation order fails to comply with the order without legitimate reason, there are some sanctions. If the adverse party is the litigation party, the court may find the allegations of the party that offers these measures to be true. If third party, the court issues a ruling sentencing him or her to a civil fine. Thank you.
Okay, then Judge, I'm interested in your preservation of evidence system. I think Korea have very similar system. So is it often used in Japan, and the motion for preservation of evidence is granted well?
Honestly speaking, there are a few cases. The number of petitions for the preservation of evidence related to IP cases in Tokyo District Court counts about 5 per year. On the other hand, I've never experienced and heard the petition for disposition on the collection of evidence related to IP cases. It is pointed out that there are some problems such as efficiency, effectiveness, and difficulty of procedural requirement when considering pros and cons. Thank you.
Okay, thank you, Judge. And then how about in Germany, Judge Feddersen?
Now, the German law of civil procedure does not provide for common law style discovery. But obviously, in many cases, if the product is not readily available on the market that you assume to be infringing, you have to have some means to get a hold of the potentially infringing embodiment. So there are a couple of claims in the German substantial law to get to that for that purpose. I also should say that evidence collection is led by the court upon application of a party. So no discovery. It's all up to the court to collect evidence. upon application of a party. So we have a couple of claims that enable the patentee to request the other party to present the contested embodiment or to inspect the contested embodiment, but these substantial claims have a prerequisite of, probable infringement. So what do you do if you just don't know whether the embodiment is infringing or not? So there's another procedural measure which is called independent evidentiary proceedings. And this is a very low hurdle to take because you can apply for this independent evidentiary proceeding if there is the concern that evidence might be lost or that it will become difficult to use it. So of course you need some, facts that justify this claim, maybe previous behavior by the other party, suspicious behavior, concealing things. But more importantly, there is even, I think, a lower bar, you would say, because these evidentiary proceedings can also be initiated if, regarding to the state of an object, examination of the state of an object, meaning the embodiment, if the applying party has a legitimate interest in establishing such evidence. And the provision itself tells us what a legitimate interest can be, namely, if the establishment of these facts, the state of an object, may serve to avoid a legal dispute. And that is a very broad prerequisite because, what are we doing? No, we actually are deciding trials, but what are the lawyers doing? They are trying to avoid trials. And in order, if you want to find out whether an embodiment is infringing or not, you are basically under this broad provision that you are trying to avoid, or possibly trying to avoid trial. So this is a quite low bar, as I said, for getting access to the contested embodiment. And I should add, in very generally, that if the other party doesn't comply with it, then the full force, the full police force will come and support the bailiff, upon getting access to the contested embodiment.
Thank you, Judge Feddersen. I think even though you do not call the preliminary inspection proceeding as discovery, but it sounds like one of the discovery in the United States. So is the preliminary inspection proceeding often used in your court?
Now, this is something I really love about comparative law, comparative procedural law. We might, have the feeling that everything is different everywhere and that we call things different names, but we all are, working toward the same or similar goals. So we use methods that are kind of similar. And so I have to agree, as I said, the bar is very low. And also, I apologize for not being an expert, but I think even in discovery, a court might be involved, granting discovery to certain documents and so on. So yes, it's maybe not that different, and it's a very effective and also very often used method.
Very often used. Oh, good. Okay, then how about in Korea, Judge Jörn?
When I listen to Judge SUGIURA, I feel we share similar changes. I think. Yeah. In South Korea, the Civil Procedure Act doesn't include discovery process like in the U.S. Yeah. I can say we have a judicial-led evidence collection system. In patent infringement cases, parties can request a material submission order to compel the opposing party to submit evidence. This provision is more powerful than the document submission order under the Civil Procedure Act. Notably, under the Patent Act, this order extends beyond only documents, even if the requested material contains trade secrets. The party cannot refuse submission if the information is essential for proving infringement or calculating damages. If a party fails to comply with the order without good reason, the court may deem the opposing party's assertions regarding the content of the material as true. Furthermore, if it's highly impractical for a party to make detailed claims about the contents of certain materials, and proving the facts with other evidence isn't realistic, the court may deem not only the contents of the materials, but also the facts the party aims based on them as true. Additionally, a party may apply to the court for a preservation of evidence under the Civil Procedure Act. For evidence preservation, a preliminary hearing isn't required. Only notification of the date of evidence collection is needed. Moreover, if there are urgent circumstances, even this notification can be skipped. The only condition for this procedure is that without preserving the evidence in advance, it would be difficult to use it later. It doesn't need substantial suspicion of infringement. Yeah. However, the need for preserving evidence seems to be judged quite strictly, and some people believe that this strict standard creates an obstacle to more active evidence preservation.
Okay, thank you, Judge Jörn. That's why we have much interest in adopting some U.S. systems. So, Judge Matsumoto, United States is famous for its discovery, right? Yeah, so even though it has some pros and cons. So, would you just elaborate on the sanctions about the discovery? And one more question is that the sanctions could be imposed often against the parties? Would you?
Yes, in the United States, the Federal Rules of Civil Procedure govern discovery. The scope of discovery is very broad. As long as it is non-privileged and is relevant to any party's claim or defense, it may be discovered. So discovery comes in different forms. You can ask written questions and ask for a verified answer, meaning it has to be verified by a person with knowledge. You can ask for documents. You can ask for inspection of an object. And if a party does not comply, the first step is to obtain an order compelling discovery from the judge. The judge will then set a date by which the party must comply with the discovery request. If the party still refuses or fails to comply, Rule 37 of the Federal Rules of Procedure provide a broad range of sanctions. One cannot apply for sanctions until there has been an effort to consult in good faith with the withholding party and try to resolve it. But when you do invoke the judicial power to resolve a discovery dispute, the court may order the following sanctions. It may order that the matters embraced in the order or other designated fact is taken as established, similar to Japan and Korea. It may also prohibit the disobedient party from supporting or opposing designated claims or defenses, or from introducing designated matters in evidence. It may also, the ultimate sanction is dismissing the action or proceeding in whole or in part, or entering a default judgment against the disobedient party. The court also has inherent power to impose a contempt order, which is an order that has both civil aspects, meaning I can impose a fine of $100 per day until you comply with my order. And there's also criminal contempt, which is really the ultimate sanction where you can imprison somebody for not complying, but that rarely happens. So yes, sanctions are available. The court can also award the cost of attorney's fees against the withholding party if a motion to compel is necessary.
Thank you, Judge. And all the sanctions are stipulated in your FRCP, and also you have inherent power, right?
Yes, we do. Thanks to Article 3 of the Constitution, the courts have inherent power to manage their dockets in a way that addresses the interests of the parties, the public, and moves the litigation along in an expeditious and fair manner.
Yes, I'd love to take your inherent power. I like it. Okay, we have a long way to go, so let's move forward. This pre-trial and trial phase. Let's United States again. Just much more time, sorry to ask you again. Question is like this. Are there specific directions or procedures that courts or judges adopt to ensure efficient hearings during the pre-trial and trial phase?
Well, in addition to what I already described with the pretrial conference, there are also methods within the Federal Rules of Civil Procedure for a quick disposition. Those include motions for summary judgment, and they usually occur after the parties have had an opportunity to exchange discovery of the facts, and once a party realizes or decides that the facts, certain material facts are undisputed, a party may move for summary judgment, meaning they can ask the court to award judgment in that party's favor based on the undisputed factual record, and they must present not only the undisputed facts, but also a legal memorandum showing that as a matter of law, that party is entitled to judgment. So Celotex Corporation versus Ketret is a Supreme Court case decided in 1986, which established and urged parties to consider summary judgment. So that is a very effective tool to get to judgment without a trial.
Okay, thank you, Judge. You shared summary judgment practice and JMO practice, right? It is very strong framework for your court.
JMAL is judgment as a matter of law, and that occurs at the trial phase. Once a party, like a plaintiff, has been heard fully in presenting its evidence, the opposing party may move for judgment as a matter of law, either on a claim or a counterclaim. So the plaintiff can also make this motion. What the party must show under Rule 50 of the Federal Rules of Civil Procedure is that the party has been fully heard and the opposing party makes the argument based on the trial record that the facts are insufficient to support a judgment in favor of the plaintiff, or they are insufficient to support a defense that a defendant has raised. And the court will then basically withhold the case from a determination either of itself or by the jury, and may enter judgment as long as the party has been fully heard.
Okay, so JMO is raised before the trial and after trial once again, right?
It's raised during trial after a party has finished presenting evidence, and then if it's denied or reserved, the losing party can then renew the motion within, I believe it's 28 or 30 days after judgment.
Okay, thank you. Then Judge Yoon, could you share some Korean practice about this matter?
Yes, thank you. When the IPI court schedules a hearing, it sends an order to the parties requesting them to submit a summary of the key issues at least 7 days before the hearing date. This order includes guidelines for preparing the summary as well as information about the hearing procedures and requests for cooperation. For detailed information, please refer to the sample order form attached to the conference materials. Thank you.
Okay, thank you for your brief explanation. Yes, next phase is post-trial phase, but in this phase, I could find that there is common practice for efficient dispute resolution, that the courts, all the courts, are encouraging the parties to resolve their disputes through mediation, conciliation, or other ADR procedure, like Judge Rader mentioned, settlement is the best, right, to judges? Okay. Next phase is the judgment, right? The most important thing for the judges. let's visit Japan first. Judge Sugiura, question is like this. Does your country, Japan, has systems or practices that help judge reduce the workload of drafting judgment?
Thank you. We have no special system to reduce the workload of drafting judgments. We continuously make effort to reduce it, and submission of electronic files of documents by parties is one of the useful methods. At present, we are discussing and attempting the improvement of the format of judgment. For example, there are many cases that the court makes tables by Microsoft Excel. Oh, okay. Sorry. There are many cases that the court makes tables by Microsoft Excel describing parties' allegations and evidence in cooperation with parties and attaches them to judgments.
Oh, attaching some part of the argument or contentions. I think it sounds great. So does the judges like it, right? And how about the attorneys?
It's case by case. It's a very tough work to complete the table, but when we complete we made the complete table, it's very useful to share the common awareness between the parties and the court. For example, sometimes the defendant alleges the defense of the invalidity, and in such case, there are some, or maybe 6 or 5, five or 6 or 10 variety of such defense. In such case, it's difficult to share the common awareness of the issues. But if we make such table, we can the awareness share easily.
Okay, thank you. Yes, lessening the workload of judges is common concern about the judges, right? Then attaching the part of the argument, how about the high court judges? Do they also like it, or the justice also like it? One more question.
In the judgment by appellate court, sometimes I watch they use the table according to the first instance judgment.
Okay. Then, Judge Matsumoto, would you share USA practice about this matter?
In the United States, we're lucky to have law clerks who are generally young lawyers who have passed the bar and have maybe 1 or 2 years of experience in actual practice, who come and spend 1 year with us in our chambers. So when we have a large case or motion, we have a conference, we talk about the legal issues involved, we receive the papers from the parties, and then we talk about how to draft a decision. So I believe, I don't know, were you going to show them that judgment or not? No? You don't have to. Okay.
Do you want me to share this one?
What I wanted to explain is, under Federal Rule of Civil Procedure 58, a judgment must be set out on a separate document. So what you see here is not any legal reasoning, it's just a simple judgment after trial. This involved a products liability claim against BMW for what's called a soft closed door, where the plaintiff lost a tip of his finger in a door that closed without notice. So in this case, the jury awarded over $1 million in damages. But what isn't here is the post-trial decision, we call it a memorandum and decision, which judges write. I believe my M&O in this case was about 80 or 90 pages, and in that decision what I did was, in response to BMW's motion to set aside the verdict, I set forth all the trial evidence that supported the plaintiff's judgment of over $1 million, showing why the jury's award was not out of line, that there was sufficient evidence to support it, and that the amount of the judgment did not shock the conscience in any way.
Yeah, thank you, Judge, for sharing this judgment. But after this very simple judgment, there might be some settlement, right? In many cases.
Yes, I had another case involving BMW, and it went through a 2-week trial. This was a alleged faulty tire pressure warning where the car ignited on the freeway. The young woman driving the vehicle had about $400,000 of jewelry in the car that she was driving to a trade show. So it was very hotly contested, no pun intended, but the jury awarded judgment against BMW. They filed an appeal, but during that process, after the judgment was entered, they negotiated a settlement, and the case was finished, and the appeal was withdrawn.
Okay, thank you, Judge. Actually, these days, Korean judiciary is also considering to adopt very good practice for simplifying our judgment. So I think it is a good example for us. Thank you. And let's move forward. And filing appeal. Oh, always judgment is not the final, right? The attorneys like appeal. This question, let's begin with Germany, Judge Feddersen. Yes, question goes like this. Do your country's appellate court review the lower court's decision in an ex post manner, solely based on the case records compiled in the lower court, or continue the lower court's case and hear and review the case again?
Thank you. I have to apologize in advance because this is a little bit complicated and technical stuff, so bear with me, please. Now, the appellate courts, the higher regional courts, as I mentioned earlier, base their decisions on the facts established by the court of first instance. This is like the ideal situation, unless specific indications give rise to doubt as to the court having correctly or completely established the facts relevant for its decision. So if there are doubts as to the fact-finding of the lower court, the appellate court will engage in its own fact-finding mission. Also, there is a restriction if you want to enter new means of challenge or defense. These are only admissible under limited circumstances if they concern an aspect that the court of first instance has recognizably failed to see or has held to be insignificant. Also, if they were not asserted in the proceedings before the court of first instance due to a defect of the proceedings. Obviously, if there was a mistake in the lower court while fact-finding, then you have to repair that on appeal. And also, if a party wants to add something new that wasn't part of the substance in the first instance, then it may enter this new information if it wasn't due to the negligence of the party to enter the information earlier. So this is, if you will, like a standard of negligence at this point. So in this respect, the appeal is on points of facts, on points of law, obviously, but also on facts under the limited exceptions I have mentioned.
Okay, I understand. Thank you so much. Then, Judge Jörn, how about in Korea?
Thank you. In our legal system, the appellate court is designed to continue the lower court case. Therefore, in principle, the procedures in the appellate court are similar to those in the first instance. However, some judges be stringent about accepting evidence submissions that could have been presented during their first trial, but were not. Especially, it's very challenging to reintroduce expert evaluations or witness testimonies that were already presented in the first instance, unless there are significant concerns about their credibility. Yeah, thank you.
Thank you, Judge Yoon. And then Judge Matsumoto, you have Federal Circuit in Washington, D.C. Would you share some practice in the Federal Circuit?
As we know, the Federal Circuit in Washington has exclusive jurisdiction to hear appeals from Article III courts, which are the district courts, and the United States Court of International Trade, and also may hear cases involving patent, trademark registrations, and other subject matter from certain Article I courts, including but not limited to the United States Trademark Trial and Appeals Board and the United States Patent Trial and Appeals Board, also known as PTAB, and the United States International Trade Commission. The review of the appellate court is limited to the evidentiary record of the lower court. So the Federal Circuit applies different standards of review for issues involving anticipation or obviousness, and that is because they review this as a matter of law versus fact. So anticipation is deemed a factual determination. That's Eli Lilly versus Zenith, decided in 2006. A patent is invalid as anticipated if the invention was described in a patent or published application before the invention by the patentee. And this means that the court is determining whether each element of a claimed invention is disclosed by a single prior art reference. For appeals on factual issues, the Federal Circuit applies either a substantial evidence standard of review or clearly erroneous, depending on the source, meaning what court decided this matter. When reviewing a decision from the PTAB, for example, the Federal Circuit will apply substantial evidence. This deferential standard asks the reviewing court to determine, quote, whether a reasonable fact finder could have arrived at the board's decision based on the available evidence. If the decision originates from a United States District Court, the Federal Circuit applies a clearly erroneous standard, which overturns the District Court's decision only if it is found to be clearly wrong. A finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire record of evidence is left with a definite and firm conviction that a mistake has been convicted. Did you want me to talk about the standards for review for legal issues?
Yeah, if you want, please proceed.
All right, obviousness, by contrast, is considered a question of law with underlying factual determinations. So the reviewing court is asked to decide whether, in light of prior art, the claimed invention as a whole would have been obvious to a person of ordinary skill in the field at the time of the invention. Thus, the court reviews the factual underpinnings, such as scope and content of prior art, the level of ordinary skill, and the claim invention for clear error, but it also then reviews the district court's ultimate legal conclusion on obviousness de novo, meaning the appellate court can reevaluate that conclusion and decide it independently without deference to the lower court's decision.
Okay, thank you, Judge. And the standard of review might be different from bench trial and jury trial, right? If it goes with a bench trial, it might be reviewed by substantial evidence review standard, and if it is a jury trial, whether it is, if it is bench trial, it is whether there is some clear erroneous, and if it is jury trial, it is supported by substantial evidence, right?
When a fact finder, whether it's a jury or a judge in the federal district court, deference is given to credibility determinations and weighing of the evidence. So there's deference in that regard, and the appellate court generally is very reluctant to question credibility determinations by either a jury or a judge at a bench trial.
Okay, thank you so much. Actually, Germany, Japan, Korea belongs to similar countries, and United States is belong to commoner countries. So we have different two systems. So in the United States, the Federal Circuit review the cases in ex post manner, right? So I wonder whether the judges like it. The Federal Circuit judge and district judge might be different, right? How do you?
I think that as a district judge, of course you want to get it right, and of course you want to be correct on the law, and of course it's a little bit difficult to be reversed, but it is part of our job to do our best, and so litigants have a right to appeal, and they may seek further review of our decisions, and from time to time, not often, but sometimes the Federal Circuit will disagree and reverse. And that's fine.
Okay, recently I found that the reversal rate in IP High Court is a little bit higher than Federal Circuit because the difference of the system, right? As Judge Yoon mentioned, the parties can submit new evidence even in the appellate level, so that's will be similar in Japan, right, Judge Sugiura? All right, okay, well, we already finished the, the infringement litigation, and it means that we are over the hump. Now, let's talk about administrative revocation litigation. Start with overall system. Judge Yoon, will you start with the answer about this question? Please explain any systems or local rules adopted for efficiently handling the revocation appeals.
Yes, thank you. The IP High Court has established the guidelines not only for the civil appellate cases mentioned earlier, but also for revocation appeals. Then these are also posted on its website. The court issues an order to prepare for elucidation before hearings in revocation appeals as well. Parties generally follow the court's guidance of resulting in revocation appeals concluding after a single hearing. Notably, the IP High Court encourages the use of a presentation to facilitate efficient oral hearings as stated in Section 2.8 of the Guidance and Cooperation requested for trial proceedings. You can see the guidance on page 262 of the conference materials. In practice, most hearings involve oral arguments supported by PowerPoint presentations, which significantly aid in understanding the case. To maintain efficiency and ensure fairness, the court inquires about the time each party requires for their presentation before the hearing. A fair amount of time is then allocated to both sides, and a timer installed in the courtroom is used to strictly manage the allocated time. I think the litigators often the pressure that taking timer like that, and right now, so do I. Looks like it's time for some mutual understanding. Yeah.
Sorry, Judge, interrupt you. You want to share this picture? Yes. Yeah. There is some clock, time clock, for that timer. Was it the Chief Judge's idea?
Judge support the timer by budget.
Okay, thanks, Chief Judge. And what if the attorneys want to get more time for their presentation? So more time will be given, right?
Very difficult question.
You are not a presiding judge. Normally, what if the attorneys want to get more time because the case?
Presiding judges, I'm not presiding judges, so I can tell something atypical.
Okay, anyway, some additional time will be given to the parties, but for the same time will be given for both parties anyway. Okay,
Yes.
let's visit Germany. How about in?
No, I really like this time limit thought. This is amazing. I think this is something you share with the... Well, now the Federal Patent Court decides appeals against administrative decisions of the Patent Office. You remember that I talked about bifurcation earlier, so we have different venues for revocation and nullity on the one hand and infringement on the other hand. The appeal has to be submitted within 1 month after service of the administrative decision. Oral hearing is optional, no time limit, but written proceedings are the rule. The court, again, can set deadlines for statements of the parties, and on average, appeal proceedings last between 9 and 24 months. In nullity proceedings, the defendant can raise an opposition against the complaint within 2 months from service of the complaint, and the court shall indicate to the parties as early as possible those aspects which will presumably be of particular significance in respect of the decisions, or which are helpful for concentrating the oral proceedings upon the issues which are essential for the decision. And now I have to mention a new provision, because such indication is, as a rule, that's the wording of the provision, as a rule to be made within 6 months following service of the action. And this is a provision that you have to understand before the background of bifurcation, because as I pointed out, it is possible that infringement proceedings are on their way and actually overtaking revocation proceedings, which are not as fast as infringement proceedings, because on average, infringement proceedings in first instance last for 1 year, maybe. And as I said before the Federal Patent Court, it can take up to 2 years for the revocation proceedings. So you have to deal with this thing that some people call the injunction gap, meaning that you might get an injunction on basis of a patent that later is being found invalid. And so what can you do about that? Well, I have to say the regional courts are very diligently in assessing the validity of patents, and they will only grant an injunction if they are of the opinion that it is more likely that the patent will hold than not. And also the Federal Patent Court, as I mentioned, is asked to issue a preliminary assessment within 6 months of filing the revocation action. This obviously is meant to, speed up the revocation proceedings, but it also might help in the infringement proceedings, because the regional court has some assistance from Munich, right, telling them what the Federal Patent Court is thinking about the patent. So this is a quite important measure, and so I think on the whole, I mean, you won't be surprised by this assessment. On the whole, we are managing quite well as to the so-called injunction gap. Well, then again, the Federal Patent Court may set a time limit within the parties may submit final comments, and also extensions are possible. The average duration of nullity proceedings is also up to 24 months. Thank you.
Thank you, Judge. Actually, Germany is famous for its strict bifurcation system, and at the last year's International IP Court Conference, your colleague Judge Klein at the Munich District Court shared this amendment of adopting the preliminary assessment of the nullity case, right, from the Federal Patent Court. So I have some follow-up questions about this interesting system. How does it work in practice? I mean, the preliminary assessment of nullity case. Is it a actual binding to the judges, not just a recommendation? Then don't the judges feel burdensome about changing their preliminary assessment after hearing the case? And then one more thing is, doesn't it even make the judges hesitate to render a quick preliminary assessment?
Thank you. Now, first of all, I don't have statistics on me as to in how many cases the 6 months are met or not. But as I stated, the wording of the provision says that as a rule, you have to publish this assessment, this preliminary assessment, within 6 months. So there would be it would be required that there are, some unusual circumstances that require longer time, more time. So I would assess that as a rule, usually you will get this assessment within 6 months. Now, to your second question about the, would the judges change their point of view? Are they feeling burdensome? And now please brace yourself, because I'm going to start preaching. And this...
Sorry, Judge, would you tell me that part again? Second question. Doesn't it even make the judges hesitate to render a quick preliminary assessment?
Now, I mean, the judges have to comply with the law, right? And so I would expect that they even if they feel hesitant, they might have to overcome this feeling and issue the preliminary assessment. I have no doubt as to that they will be able to do that.
Okay, then one more follow-up question to make it more clearer. So what if there is some judge who does not render a preliminary assessment even until the deadline? What happens?
Actually, I'm not quite sure, because this is so new, and I'm not familiar with cases where this hasn't been complied with. I think probably there will be no specific remedy for that, because it's a procedural decision or procedural measure, in an ongoing trial. So I would expect that, this would not reflect well on the judge's practice, but probably there's no legal remedy for that. But I mean, I promised you to start preaching. May I do that? Because this refers to something that Judge Matsumoto has mentioned earlier, and I refer to your question whether judges feel uncomfortable changing their preliminary assessment. And I would say it is our professional duty to reflect on our own points of view and to evaluate them in the light of additional or new information at any time before rendering a judgment. So there should be no shame in correcting ourselves if we find that we made an erroneous assessment, or that we have to modify our view in light of additional information.
Thank you, Judge. It is a new system, so you need more practice and precedent, right? And so please visit this conference next year with more practice.
I certainly will. Thank you.
Thank you. Let's move forward. And patent claim amendment is one of the really hot topic for patent, litigation. Yes, let's visit Japan. Judge SUGIURA. Question goes, does your country restrict or prohibit the filing of amendment to patent claims or the initiation of amendment proceedings during the revocation action against patent invalidity decision?
Thank you. Yes, the Patent Act provides on the requirements to correct claims, so the patentee cannot correct the claims during revocation action against patent invalidity decision. For example, as for the correction trial, a request for correction trial may not be filed between the time that a trial for patent invalidation becomes pending before the Japan Patent Office and the time the ruling on the trial decision becomes final and binding. Thank you.
Judge, I heard that restricting your claim amendment during the revocation appeal or trial is adopted in 2011. Is that right?
Yes, exactly saying a request for correction trial may not be filed between the time that a trial for patent invalidation, for example, is filed against JPO and the time that the trial decision becomes final and binding. The duration may include the period that suit against trial decisions made by JPO is filed to IP High Court and its decision, judgment become final and binding. And the system is adopted by the 2011 amendment of Patent Act, and one of the reasons is to solve this complicated situation. And before this amendment, in case that the correction trial is filed before JPO, while the court is dealing with suit against trial decisions by JPO, the court may send the case back to JPO. It was compared to catchball in baseball and criticized strongly. After this amendment, such harmful situation is resolved and the proceedings of the trial for patent invalidation progress smoothly. Thank you.
Yes, actually in Korea, while we are hearing the case before IP High Court, the patent owner want to visit the PTO again and want to try to change their patent scope, right? So it is one of the cause of delay in our patent litigation. So can you tell us more about some changes after the amendment, like after adopting the new system, restricting the amendment?
It's completely changed the system. So it's quite difficult for me to explain the effect of the amendment based on the statistics or data. But I guess the strategy by patentee as plaintiff will be changed because as you may know, Japan adopt it's called the double track system. It means the patent invalidity process against JPO and the IP High Court, and the patent infringement litigation are running simultaneously in some cases. So the patentee as plaintiff make a strategy when or whether they request the patent claim correction of claim, and or they don't file to claim of correction, but in the patent infringement litigation, they allege as a rebuttal against the defense of invalidity by defendant. It's the the patentee can select the way to struggle between the defendant. Thank you.
Let me make it clear about this point. So while some litigation is pending before the trial about the revocation case, can the patentee visit the Japan's patent office again to amend their claim? It is not, right? During the revocation litigation, to initiate their new claim to amend their claim.
During the revocation, the patent invalidation, the patentee have chance or opportunity correct the claim when JPO informed their preliminary decision about the invalidity of the patent. In order to respond to such a decision, the patentee can correct the claim.
So it'll be announced in advance. It might be invalidated. So yeah, Japanese system sounds sophisticated. So let's study more. Okay, Judge Matsumoto, would you just briefly explain some reissue practice, just briefly? Reissue practice. I know the United States reissue is used for correcting the claims scope, right?
Well, I think what the system wants to avoid is duplication of efforts and expense by the parties and by the adjudicating body. So in the district court, we can stay our proceedings while a party seeks review. That stay decision is immediately appealable to the Federal Circuit. And during administrative review of patent claims, patent amendments are governed by 35 U.S. Code Section 316D, which allows for one motion to amend, so long as the amendment does not enlarge the scope of the claims of the patent or introduce new matter. If the motion is accepted, the amended claims are to be assessed for patentability alongside the original instituted claims during the proceeding. Now, amended claims are entered into the inter partes review, but not into the patent itself. The patent owner does not bear the burden of persuasion on patentability in motions to amend during the revocation proceeding. However, the board can rely on provisions such as 35 U.S. Code Section 112 to deny motions to amend the patent claims. During a revocation action concerning a patent validity decision in PTAB, the American Invents Act provides that a patent holder may amend again as long as they do not enlarge the scope of the claims of the patent or introduce new matter. Now, thank you. I don't know if that addresses your specific question, Your Honor.
Okay, thank you, Your Honor. I think in the United States, the reissue is a little bit widely allowed, right? Seems like that. Okay, thank you. I think we are approaching the last hill. This estoppel is very difficult topic. The question goes first to Judge Feddersen. Is it okay, Judge Feddersen? Last hill for you? Okay. Please explain any system in your country applying the principle of estoppel to ensure efficient and cost-effective litigation proceedings. And one more. Specifically, in the infringement litigation involving the same patent, can the patentee present claim construction arguments that contradict his or her previous assertions or which had been made during the patent filing, patent appeals, or other civil litigations? Would you answer?
I'll try, thank you. To your first question, there is no doctrine of estoppel in German procedural law. However, According to Article 138 of the Civil Procedural Code, the parties are to make their declarations as to the facts and circumstances fully and completely, and are obliged to tell the truth, surprisingly. Furthermore, parties to court proceedings are bound by the civil legal obligation to perform according to the requirements of good faith, which may be violated by contradictory behavior. Thus, a party may, and also may be obliged to, specify, complete, or correct prior statements. And if that happens, contradictory statements of a party are not automatically deemed irrelevant. Rather, pursuant to Article 286 of our procedural code, the court is to decide at its discretion and conviction whether an allegation as to fact is to be deemed true or untrue. Therefore, it is standing case law that the court has to exercise discretion as to whether it regards a statement of a party that contradicts prior statements as true or untrue. And I was just about to answer the second question. This is specifically like a patent, patent law issue. The Federal Court of Justice has indeed decided that a patent holder cannot claim infringement of a patent if in opposition proceedings he has disclaimed protection of the now contested embodiment produced by a party of the opposition proceedings, because this behavior violates the obligation to perform according to the requirements of good faith that I mentioned before as a general civil legal principle. Thank you.
Thank you, Judge. And it falls under the discretion of the court whether to apply that principle or not.
Correct.
Okay, how about in Japan, Judge Sugiura?
Thank you. In Japan, the principle of estoppel is understood as one of the expressions of principle of good faith, and the Civil Procedure Code provides it as a general principle. Therefore, if an action by party in civil litigation procedure has violated the principle of estoppel, the court may dismiss it or deal with it as invalid action or deny the effectiveness. There are no laws to provide about the principle of estoppel about claim construction. However, it is a common understanding related to the patent infringement litigation as well as the litigations against Jaepil's decision that the prosecution history of the patent should be considered when claim construction is implemented. Of course, file wrapper estoppel is considered as a matter of course. Thank you.
Thank you, Judge. Then it sounds similar to Germany's system. Okay, thank you. And then how about in the United States, Judge Matsumoto?
Well, we have different kinds of estoppel with the overarching goal of preventing parties from relitigating the same issue more than once. So judicial estoppel is a more, I guess, akin to the district courts, the trial courts, where you cannot take a position contrary to a position you've taken in the same litigation or in an earlier legal proceeding. Collateral estoppel or issue preclusion prevents a party from relitigating an issue previously resolved in a lawsuit or in an administrative proceeding, even if the issue relates to a different claim. Any party may assert collateral estoppel, and it would apply only when the party against whom collateral estoppel is asserted had a full and fair opportunity to litigate the issue previously. Also in the United States, courts recognize res judicata or claim preclusion and collateral estoppel issue preclusion, which again avoids relitigation of the same claim. The Federal Circuit has held that collateral estoppel applies in patent cases when the defendant had a full and fair opportunity to litigate the issue was actually litigated, and the controlling facts and applicable legal rules were the same in both actions, and resolution of the particular issue was essential to the final judgment in the first action, and the identical issue was decided in the first action. The U.S. Congress has also created inter partes review specific estoppel, which is conducted by the Patent Trial and Appeal Board in 35 U.S. Code Section 315. The petitioner in an inter partes review of a claim in a patent under this chapter that results in a final written decision may not assert either in a civil action or in a proceeding before the International Trade Commission that the claim is invalid on any ground that the petitioner raised or reasonably could have raised during inter partes review. So those are concepts, again, to avoid duplication and expense.
Thank you, Judge. Not only have been raised, but also could have been raised, right? The Peter estoppel applies. Okay, in the United States, you have judicial estoppel, collateral estoppel, claim estoppel, claim estoppel and Peter estoppel. I think in the United States, estoppel works as a very strongest framework to make the process very effective, right? Is that right?
It's an equitable doctrine, and in the United States, we value the concept of finality. You know, the parties have spent money and time litigating a matter in whatever form they choose. Once an adjudicator makes a decision, the idea is finality. And of course, they have appellate rights, but we don't want somebody coming back and forum shopping and bringing the same claims over and over again.
It sounds good. Then this estoppel defense often raised and well granted. I mean, will be successful with this defense, estoppel defense?
It is raised, and at least district courts, and I believe the PTAB and the Federal Circuit would look at this issue and either uphold the lower court's decision or find that it wasn't barred.
Okay, thank you, Judge. Finally, we reached this final question, hypothetical question among the judges. Okay, today, during this session, we discussed various systems to make our process efficient, right? So among all the litigation systems discussed today, which one would you like to bring with you in your suitcase to make your jurisdiction more attractive? Who will go first? Anybody?
May I?
Yes, you may.
Thank you very much. If I may, I would like to propose a mixture of all the three neighboring systems that I have learned about today. So first of all, and we have talked about this before, but it is not only because of the wonderful presentation of Judge Matsumoto, but also because I have seen so many fantastic Hollywood court dramas. I really dream of the option to render orders of complaint of court, right? This is what we all dream about outside of the US. Secondly, and maybe a bit more seriously, I really like the idea that I heard from Judge SUGIURA today about technical assistance of patent courts. And I'd like to refer to the speech of Judge Jörn from yesterday, and would politely ask for admittance to the camp of Justice Scalia, at least in this respect, because unfortunately I do not have a pharmaceutical background as the very impressive colleague from Korea yesterday, for example. I'm not a technician and I'm not a physicist, so I really would appreciate technical assistance if I imagine myself deciding a technical, upon a technical patent. And thirdly, and I think I have mentioned that already. I also like the idea of time limits. Even before the European Court of Justice, the parties have page limits. So if you want to render your claim, you have to. I think you have 15 pages, and you have to really be brief and very concise. So I also like the idea of time limits, which I also have witnessed in front of as a spectator in front of the U.S. Supreme Court. I think each side has 30 minutes, and this is mercilessly enforced. So these are the three elements that I really like and would take with me in my suitcase if customs would allow it. Thank you very much.
Would you give him a big applause? Thank you, Judge, but I think your suitcase might be full, right?
How do you know?
Who will be the next? Okay, Judge Jörn.
Honestly, I couldn't pick just one, but I can share one appealing system from each country that caught my attention. In the US, definitely strong and specific sanctions imposed by courts enhanced the efficiency of proceedings. I don't know how did the litigators think about that. In Germany, I was impressed by the strict penalties, including fines or even detention, imposed for violations of inspection orders. Japan's regulation, which restricts claim amendments during revocation actions challenging patent invalidity decision, is also a mechanism I feel is necessary to consider for adoption in our system. Yeah, thank you.
Thank you, Judge. I think you already found many things to make our IP High Court more attractive, right? In this session. Okay, thank you. Who will be the next? Okay. Oh, sorry. He was faster.
Thank you. Actually, I myself face the difficulty to collect the evidence concerning the calculation of damage. In some cases, the defendant strongly resists to disclose their financial documents, but the system I introduced this session, I think it's still not function sufficiently. So I'm very interested in the way to collect such documents among these countries. Thank you.
Thank you, Judge. Thank you for sharing your good experience and opinion. Yeah, the heroine comes last, right? Judge Matsumoto.
Well, like Judge Feddersen, as I said at the beginning, we are courts of general jurisdiction, and I am not a science, engineering, technology person. That makes our job very interesting, but also more challenging, and I would welcome more technical help. And I think that there's something to be said for specialized courts. So, for example, when Judge Cheney yesterday described the fact that he has people on his court with engineering backgrounds, I think that's wonderful, because I had a case involving retractable roofs over stadiums, and there were principles of engineering and physics that were very difficult for me to grasp. I do commend the lawyers who practice in this area, because their job is to teach the judges about the technology, and I think they do an excellent job. I also appreciate the fact that there doesn't seem to be this parallel proceeding in other countries where a court may be devoting a lot of time and resources to resolving a dispute, but meanwhile there's an administrative proceeding that may invalidate the patent and render our work and our jobs null and void. So it's a very inefficient situation, and I think the American Invents Act is trying to address some of these inefficiencies.
Thank you, Judge, so much. Okay. Now it's time to open the floor. Okay, I'd like to welcome one or two gentlemen or lady. Okay, over there, the first. Yes, in the middle. Sorry. Next.
Thank you. Thank you all for sharing your insights. My name is Jung Eun-yoon. I am the judge of IP High Court of Korea. And I have questions for Judge Matsumoto from United States and Judge Feddersen from Germany. I think I feel similar difficulties when assessing damages in my cases with Judge SUGIURA. So in Korea, there is a currently ongoing issues, discussion about improving evidence collection procedure system, focusing on the finding some balanced approach between United States and Germany. So here's my question. To best knowledge of mine, I know there are some several discovery tools in the United States in civil cases. So what is the most powerful and strongest discovery tool in the patent infringement cases in the United States? And for the Feddersen, the Article 143 of the German Patent Act, I know that this article is the distinctive tool from the general civil cases. And so I'm wondering that how often is this applied to actual cases? Thank you.
Thank you, Judge.
I think that all of the discovery tools used together can be very effective. Usually at the beginning, there's automatic disclosures that must be made by a party, both parties in a litigation. The least expensive discovery tool is interrogatories, meaning asking written questions to be answered. Also requests for admissions, where a party can ask a plaintiff or a defendant to admit certain facts or to identify or admit that these are your contentions or your defenses. The third is documents, which can be expensive if they are voluminous. There are tools that one can use in discovery to search and sort documents. There's also, as Judge Feddersen was explaining, an ability to examine the infringing object. And many times issues of secrecy or confidentiality will arise. A judge can impose a protective order where the parties agree to be bound to not disclose information they learn. The only issue that arises that complicates things is ultimately when a judge makes a decision on a matter, it might have to use some of that protected information. And that becomes what we call a judicial fact. So if a judge needs to rely on certain factual information to render an intelligible, understandable decision that explains his or her reasoning, the court will usually tell the parties, look, these are important facts that are going to be fundamental to my decision, and in order for my decision to have any use to beyond the parties to the litigation, certain facts may have to be disclosed. And I think Judge Jörn was explaining his procedure, which makes a lot of sense, which is to give notice to the parties that certain facts may have to be revealed. So, and the last tool, which is the most expensive, is to take a sworn deposition under oath of a witness. And any lawyer who's evaluating the case wants to assess how that witness is going to hold up. What kind of impression will that witness make to the fact finder? And does that witness know what he or she is talking about? Or are they avoiding disclosing all the information that there might be?
So, Judge, follow question goes, and then if you are obliged to choose just one thing, the strongest one, which will be that?
When I was practicing law, I liked to do the depositions because then I know what kind of witness I'm dealing with, and I know whether that witness can be weakened on cross-examination. I know what their vulnerabilities are, and you've locked in the witness on their testimony. If they don't remember anything, then they're not going to remember anything when it comes time to present the case to the finder of fact. And so it gives a lawyer a sense of that witness, and that is an important assessment.
Thank you, Your Honor. Deposition. Okay. Then SUGIURA, are you ready to answer the second question? Okay, just Feddersen, sorry.
No problem. Please go ahead. Now, your question concerned Article 146 of the German Patent Act, and I would like to familiarize myself and you with this provision, which says any person who uses a designation on items or on their packaging, which is likely to create the impression that the items concerned are protected by a patent or a patent application, is obliged on demand to provide information regarding the patent or the patent application. So this is basically a right to information. This is the one you were asking about, right? (146).
140C, you're talking about. Judge Yun, 140C, what is about?
Yeah, I think.
I'm sorry, please understand I'm not familiar with German Act, so I might be wrong, but to my best knowledge of mine, 140C is about make the law the likelihood of evidence if parties want to get evidence, they have to show some likelihood. In civil cases, they require the higher likelihood, but in Patent Act, it says that you can get evidence even if you have a little bit lower likelihood. Is that correct?
Judge, are you ready?
I'm always ready. Now, I would say that the usual standard of probability of infringement would apply as well here. So you have to the like the court has to come to the opinion that that an infringement is the case, and I think it will apply like the usual standard of that we apply in other civil litigation as well. So I'm not sure whether this answer is really helpful, but this is.
Okay, let's leave it there, and then Judge SUGIURA. There was no more question to Judge SUGIURA? Okay. I'm sorry, but I will take easy question because we are almost there. Yeah, very easy, Judge Kalden. Easy and simple.
Okay, I'm Rian Kalden, I'm with the Unified Patent Court. For
Whom are you asking?
Yes, for our German colleague. You were saying there is a good faith principle under German law that if a party makes a certain sort of disclaimer during opposition, he cannot rely on whatever he's disclaimed during the proceedings. How do you reconcile this with the prohibition in Germany to actually look at the prosecution file at all during proceedings?
Well, I think as to this decision, that's the Datengenerator decision that I was talking about. It is about holding the patent holder to the standard of good faith and to prohibit contradictory action in that respect. So we would probably regard that as an exclusion, as a special situation where you would in fact consider the history of the patent.
Okay, thank you. Follow up?
I'm sorry, I don't understand this, how you can reconcile this, because the whole point of looking at the prosecution file during infringement proceedings is about legal certainty of third parties, which is actually in the protocol. So I really don't understand the difference between looking at the prosecution file and see what the patentee has said about the scope of claim that he's invoking and your principle of good faith, while at the same time prohibiting a party to invoking the prosecution file during proceedings.
Now, maybe this is a very special situation where we are looking at assertions or waivers that the patent holder has made in relation to a party of opposition proceedings. So maybe this is it's like a special situation because there's a special tie of good faith, if you will, between the two parties of a litigation procedure. Maybe that is the reason why we would, draw that distinction at this point.
Okay, so it only applies for the party who was actually a party in opposition proceedings himself.
That is how I read this decision, correct.
Okay, I can find many other persons who want to raise your hands, but we are at the same venue, and then you can continue after this session. It's time to wrap up, I'm sorry. It was a very intensive and fruitful discussion, right? I really appreciate all the judges' eager participation, and I also hope the audience really enjoyed this session a lot. Did you? Oh, thank you. I heard yes. And judges, now you are all dismissed from the long session. Thank you all. Thank you.